Hello everyone and welcome to the next episode of What Do I Know? I think this is episode 12. In this episode I'm going to be dealing with the shenanigans that myself and Brian and Barry, families and friends had to address and face down through April of 2021. The first point I'm going to make actually happened on the 1st of April 2021, and no, it was no April Fool's joke. As you've probably worked out, we did not hold the monitoring officer at Cheshire East in very high esteem at all. Certainly not because of how he dealt with things, it was the way he was dealing with things. There was no honesty being employed whatsoever from him, his department, nothing. We knew at this time we got investigations that are predicated on a basis of predetermination and bias and discrimination. What we didn't know about him is when he first appeared on the scene, he claimed he was a barrister. We investigated that by looking at the rolls at the Bar Standards Board. We couldn't find him on it. So, using what we had within Cheshire East and outside Cheshire East, a group of us actually made a complaint to relevant authorities. Things went quiet, and lo and behold, on the 1st of April, he pops up on the register claiming that he specialised in public law. You could have fooled me. How can somebody specialise in public law when they've got something as basic as what befell Jean so hopelessly wrong and was openly and freely following a course of complete dishonesty? Was Cheshire East had another test because we ended up having to contact the head of democratic services regards to very serious goings on at Easter time with regards to what we will always hold out to be an unlawful election that was to be held on the West Ward for Jean's unlawfully taken seat. What we had discovered is we'd had that weekend and around that time a scarecrow festival in Hanforth. Not something I could have wholly supported. I would have liked to have done, but given who was behind it and organising it, not a house chance. What we found out here is that Julie Smith was one of the organisers, and she's obviously one of the candidates in this unlawful election that's up and coming at this time. We find that she's been personally handing out Easter eggs to children on the West Ward whose parents obviously are registered voters. Now you can see where we're going with this. You pull in our experience, our knowledge, our depth, our know-how, and automatically we're blowing the alarm bells on this one. This can't happen. It's a non-starter. It's a no-no. It's an absolute no-no. So we wrote to the head of Democratic Services at Cheshire East, and I'm going to give you the email that we wrote, and this was sent on the 6th of April 2021. It starts off saying, I hope you are safe and well. It is with great sadness that we have to report that one of the candidates in the, and we put it in inverted commas, election, Hanforth West Ward, appears to have committed an act of bribery during this period. The said candidate is Julie Ann Smith. This past weekend, we've had a Scarecrow Festival in Hanforth, and she has been seen handing out Easter eggs to the children of voters who have placed scarecrows outside their property on the West Ward. Her presence carrying out this activity on the West Ward was heavily noted on both Saturday and Sunday past. I'll actually say we actually got 17 statements from people who noticed what she was doing. We believe that this is an act of bribery as per definition, in that she is, through this very activity, both giving herself and soliciting an advantage for an inducement for action, which could be both illegal and unethical. The said advantage would be to use the giving of the Easter eggs to the children and members of the electorate in return for votes from their parents. Can easily be seen as an act of bribery here. You've got to be so careful in elections. This is an illegal act and is also unethical. It also gives her quite a distinct and unfair advantage over the other candidate. We have attached evidence showing this activity, which includes 1. An article published by So Cheshire noting that Julie Smith is one of the organisers of the event, and 2. A posting on Hanforth Community Facebook page in response to a post by Julie Smith which states, "I would like to say many thanks to the organisers for handing out the eggs yesterday. The kids were over the moon." The activity has clearly had the desired effect, as this will influence people to vote for Smith. She had to have known, maybe, in all probability, not a cat in hell's chance, she should maybe have known, really looking at that in hindsight. No, not this airhead, no. That what she was doing was not just inherently wrong, but illegal. Even if she knew it was illegal, I doubt very much it probably would have stopped her. I don't know. It probably wouldn't. In light of this, we firmly believe that Smith should be disqualified from the election without question, and we are reserving the right to report the matter formally to the police. This we did. We actually did report to the police. This election, as is well known, should not be taking place, as it came through the unlawful disqualification of a sitting councillor, and it is now being corrupted by Smith and her actions. We are appealing for major action to be taken in the wake of this occurrence. We are also reserving the right to advise the other candidate that should acceptable action not be taken, and as it is their right to be able to fight on a level fair playing field, that this candidate, this person, does not have that. We look forward to supporting you regarding this, and we've all signed this. We supplied the evidence. Nothing got done, and the illegal election got held. To compound issues, I'm having silliness over my resignation, and I get a letter telling me that my resignation, this letter is dated the 8th of April, that my resignation had not taken effect. Rubbish, it damn well had. I'd resigned on the 14th of March, and I was not a councillor. We'd also at this time picked up the fact that there was information documents or what have we been sent to my HBC email address, which it simply shouldn't have been. Remembering back, I've covered this, January 2020, right at the beginning of it. Ashley writes to me, tells me that email address is shut down. No longer in use, can't be contacted. So why is it we're still getting stuff sent to this email address? I mean, it's already caused major problems regarding investigation, because idiots have sent stuff there, including the investigator himself, okay, in the full knowledge that I'm not using it. So it was ineffective service. It was not effective service at all. And I still, at this time, decided, right, enough is enough. There's something funny going on here. I need to find out what's going on. I need to know the full SP. So I contacted two of my best mates who, like me, are professional investigators, but their specialism is IT, forensic IT, and I said, look, I need some help. So I told them what was going on, the big ins and outs. I said, look, I think it's possible somebody could be monitoring my HBC email address. But why is it after they've been told and told, when I say they, Cheshire East in this case, been told and told and told, it's not in use. They're still sending stuff there. And now I've got proof that Ashley is sending stuff there. He was the one who said it was shut down. Unless there's something else he knows that I don't know. And I said, look, what do you need? Is it going to be easy? Can you do it? Yeah, we can do it, all right. Just need your formal instruction for it. So I filled out, formal instruction documents, and I would say served them. I sent them. I gave them to these guys, and they got onto it. And the plan, I totally agreed with the plan and how they were going to do it. Only involved the webmaster, and them going to him in their official professional capacity, or them, whichever it is, or maybe I don't know if it was him or them. It could, I don't know. And carrying out checks and doing what was needed. They told me it would take a couple of months, so we were probably looking at July, August for a result. So I said, yeah, go ahead, do it. Just go ahead and do it. Happy with that. At this time, again, Cheshire East took no action with regards to the supposed or suspected bribery that was going on. We also noticed further breaches of the PERDA rules with postings on Hanforth Community Facebook page, where there was nasty, dishonest slights against the other candidate. Now, for those of you who don't know already, I've already touched on this right back at the beginning. You can't do that. You cannot publish a dishonest statement against a candidate which you know is dishonest, with the sole intent that you're going to dissuade people from voting for that candidate based on your dishonest statement. That's a serious breach of PERDA rules. That is a criminal offence. I was disappointed, as was Brian and Barry, that nothing was happening. And you've got to remember, at this time, I was ill. I was poorly, but still trying to fight. Still trying to fight with every fibre of my being to get justice. And the more this went on, the more I realised we just weren't getting there. It wasn't happening unless we did something amazing. We did have a formal complaint that we tabled against the monitoring officer in March, on March the 9th, and that was due to come up, and we got a response from that. And for want of a better word, we got the letter on the 8th of April. It was sent to my email address. It should have gone to all the email addresses. It didn't. And it was just a complete whitewash. And it showed that Cheshire East were quite prepared to dishonestly defend the monitoring officer. They were quite willing to keep a rogue in position rather than to say, look, yeah, you've crossed the line, you shouldn't have done this, you're gone. And I'm going to read that letter out. Okay, number one, it's addressed Mr. Brewerton, and in this same letter they tell me I'm still a councillor, so surely it should have been Councillor Brewerton. But irrespective, this letter should have been addressed to me, to Brian, my father, to Mike, to Barry, a whole number of people. I'd say about 15 people it should have been addressed to, 15, 20 people. It wasn't. And this was in response to our formal complaint against the monitoring officer of Cheshire East Council, and it is laughable. I'm going to read it out for you. The letter was written by the Executive Director of Corporate Services, Cheshire East. She starts, I've been asked by the Chief Executive to investigate the complaints detailed in your email of 9th of March 2021. It's not my email, not my personal email. It was a jointly sent email. So you've got that wrong right from the off. They've been dealt with under stage 2 of Cheshire East Council's complaints procedures because they relate to a senior officer. And senior officer spelled small s, small o, poor English. I did note that. But the thing is, it was dealt with under the wrong stage. Completely the wrong stage. Anyway, as we go on. So I've got a situation where they don't know their own complaints processes. As we go on, as a preliminary matter, I note that your complaint, no, it should be our complaint because the people, all the joint signatories, is centred upon what you consider to be the functions of Council Statutory Monitoring Officer. To clarify, the list of functions you have provided overlaps with, but is not the same as that of the role of the Monitoring Officer for Cheshire East Council. So in other words, you've got all the statutory functions. So what you're saying there is you've got all the statutory functions of a Monitoring Officer, but you are not employing them. He's not doing that. So what's the point having him? Or is it a case of you don't know what you're doing? It's either one or the other. It can't be both. They finish this paragraph off by saying the role of the monitoring officer in relation to town and parish councils, small t, small p, small c, again poor English, is limited to matters of parish council's conduct, small p, small c. So in other words, you're telling me the only thing the monitoring officer deals with is parish council's conduct, just parish. What about town councillors? Well, they're not important. For convenience, each issue you have raised has been considered and responded to as follows, using the numbering set out in your letter of complaint. Our letter of complaint, not mine. So we start, failing to comply with the law, the first point, 1.1, upholding the unlawful disqualification of a councillor. Now, when I read this, you'll see how stupid this is. This element of your complaint cannot be upheld for two main reasons. Really? Firstly, the disqualification of a councillor under Section 85 Local Government Act 1972 occurs by operation of law, not by the decision of any council officer or elected member. Wrong. It occurs when a councillor has missed 6 months in which meetings have been held in each of those 6 months. It can also occur, that council has the right to have the issue brought up in full council, so elected members do deal with it. But what you're saying there is not by the decision of any council officer. So in other words, you are telling me that Ashley could not, you're confirming that Ashley could not make that decision. What you're basically writing there is you're confirming it was unlawful. That's what you're saying. Thank you. Great. Yeah. It goes on. Secondly, once the principal authority for a parish council receives a notice of vacancy from a parish council, again, poor English, small p, small c, shouldn't they? It is obliged to make the necessary arrangements for election to that vacancy. It is not within the principal authority's gift to dispute the legitimacy of such a notice of vacancy. This is where this is completely wrong and shows that Cheshire East don't understand or are willfully playing ignorance to the law and willfully backing a monitoring officer who is pursuing a path of illegality and dishonesty here. What happens is, okay, is when it comes to governance, a town and parish council is sovereign. By that I mean it has the principal say. However, if there is something that cannot be addressed, it can and has the right to refer it to the higher or principal authority, in this case Cheshire East. Cheshire East should have realised there's a hell of a dispute and should have moved in to sort it out. And when they realised with our legal advice and our case law that we were right, had the power to withdraw the notice of vacancy and force us to put up corrective notices. If, of course, we have not already managed to do that by virtue of a resolution of council. She goes on. So she's got that wrong. It should also be noted that the conduct of elections for parish councils falls within the remit of the relevant returning officer, not the monitoring officer of the principal authority. The reason we're having a go at the monitoring officer here is every time we went to Brian Reid, he brought the MO in. The returning officer brought the MO in. Right? So we had to. It concludes, I'm aware that you previously submitted details of your interpretation of the relevant law, not our interpretation of the relevant law, the absolute way the law is worked and how it works, and procedure with the above process. However, this view has not been accepted by the council. So in other words, you have taken what is law, what is correct, what is right, and you've stuck two fingers up to it. You've decided to follow a path of dishonesty. That's what you've basically confirmed there. In writing, indisputable. Goes on, 1.2, holding an unlawful election, which is what Cheshire East eventually did. This element of your complaint is directly related to that set out above paragraph 1.1. I would reiterate that the principal authority is obliged to arrange a by-election upon receipt of a notice of vacancy from a parish council within its area, and that task sits specifically with the returning officer. But what you failed to address is the fact that it has been notified that there was severe illegality over what happened regards the notification of this vacancy and that it was wrong, and that you have a duty in law to act, and you didn't do it. So again, you're showing ignorance. You say here, with reference to the attempted legal challenge by yourself, Councillors Tolver and Burkill, the Council's views that any challenge in the terms expressed was without foundation and would be robustly defended. Well, forgive me, can I just have a quick laugh at that? I'm sorry, you could have defended that all you want. You would have been absolutely smashed. You haven't got a leg to stand on, and you still don't. You knew it was wrong, you know it was wrong, but you allowed the monitoring officer to get away, basically scot-free, having committed first-degree murder. That's what it boils down to. You had allowed a clerk to unlawfully take away a councillor's seat who had not self-disqualified. Monitoring officer and returning officer knew about it and been so advised. We told you, look, we're going to mount a legal challenge, and if you're not careful, that's what's going to happen. And you sit there and say it's without foundation. What a load of rubbish. We've got leading advice from a person who's a QC and now another barrister who is now a judge. You're telling me it was without foundation. You're blowing smoke. You're blowing smoke, Cheshire East. You're blowing smoke and it don't wash off. I've been here before with you and I've beaten you before. And you writing that tells me I've beaten you again. You go on, it is not accurate to say that the monitoring officer resisted the application to make it cost prohibitive for you to pursue. It was resisted because it was misconceived. No, it wasn't. Stop lying. That monitoring officer wasted time and refused to respond. And there's a whole track record of it. He refused to respond to our solicitors. He refused to respond to other councillors. Yeah? He refused and refused. He refused to respond to members of the public who were asking questions about this. Right? He deliberately played out time to run us out of time, to take it away from us so we could not challenge. So to say it was resisted because it was misconceived is absolute, complete and utter hogwash. It's nonsense. Stop blowing smoke. It don't work. Next one. Breach of confidentiality. I have reviewed the correspondence in question. The monitoring officer's letter on the 26th of November 2020 was not intended to be confidential, and this was clarified in Mr. Hollis' letter 2nd of February 2021. Well, I'm sorry. If it wasn't intended to be confidential, why did you make it thus? You attached it to an email to us as counsellors and the client, which said clearly this email, its contents and all attachments are confidential. So that makes it confidential. So why has it ended up in the press? Why has it ended up in the hands of the public? And why are you doing nothing? Why is your monitoring officers department, your legal department, sitting there with its thumbs up its arse doing nothing? I'll tell you why. Because they're incompetent. And it shows they're following a path of predicated dishonesty against us. There you go. You then say, she goes on and says, the monitoring officer's letter does not contain any personal information or anything of any confidential nature. No, but it's still confidential because of that email disclaimer. Yeah? And then she says, and as the author of the letter, the monitoring officer is at liberty to make that assertion. No, he isn't. If it's attached to an email which has a confidentiality disclaimer, that letter is confidential. And the very second he found that it had been leaked, he should have moved in and investigated to find out who's responsible and sanction the person or persons responsible. Again, he chickened out of doing his duties. He just didn't bother. He hadn't the guts or the balls to take it on. He just decided, oh, it'll be all right, leave it. Showed a total lack of discipline and was unprofessional. Yep. So that is a load of rubbish. We have got an actual breach of confidentiality, and there'll be more on that later episode. 1.4. Involvement of Jackie Weaver in budget and preset setting. The setting of a parish council budget and associated preset are matters for the parish council itself. Yeah, well, you've got something right. Well done. It's sovereign. B. Good. We'll give you a tick there. You've got 1 mark so far. Keep going. You might get 2. I understand that the monitoring officer did indeed approach Chalk to ascertain whether they could offer any assistance to Southwold Parish Council in the light of ongoing issues there. So in other words, this is a guy, let me get it straight, this is a guy who says he specialises in public law and should know that the setting of the budget and preset is sovereign to the council. So why therefore, and I'm struggling to understand this, why therefore did he suddenly decide he was going to go and approach Chalk? Because Chalk should have immediately said, no, we can't, it's down to parish council. He should also have realised through governance and audit that they'd helped us. There are specific regulatory powers and statutory powers that can be used. And as the chair of finance, I had done just that. Got the preset set, got the budget set, done it. Yes, exactly. She goes on. It appears to me that that was the extent of the involvement of the monitoring officer and Cheshire East Council. Any further arrangements were devised between Anfield Parish Council and Chalk. No, they were not. You liar. You liar. There were no other further arrangements between Anfield Parish Council and Chalk because it had to come through me. And there was no way in the world I was going to allow Jackie Weaver to interfere in the setting of our budget and preset. Absolutely not. So to start saying and try to deflect the blame here onto HPC, I'm sorry, I think that's repugnant. I think you need to go and look at yourself and really look and ask long and hard, you know, should I have really written that in a letter? Should I have written something so classless, so valueless, so morally repugnant? Should I have written that? The answer is no. Goes on. I further understand that Jackie Weaver's assistants consisted of interim clerking duties at one or more meetings of the parish council. These duties would not extend to voting on any item, so it appears to me inaccurate to say that Mrs. Weaver had any part in the adoption of the budget or preset. The fact is, you were forwarded evidence in the letter that the monitoring officer sent to Jackie Weaver. Right? It was not inaccurate at all. Your contents of that last bit is useless. It's useless waffle. It's pointless. I don't know why you put it in. But again, we ran roughshod over that, as did our legal team. So that is just rubbish. Absolute rubbish. complaints to Chalk. So neither Cheshire East Council nor the Council's monitoring officer has dealt with any complaints related to Mrs Weaver, because such matters do not fall within the remit of the Council. Then why is it we have in our hands, our possession, 2 letters where he explicitly addresses them? He's clearly interfering. Clearly interfering. So to write this paragraph and being given those letters in evidence, you're denying a truth. You're burying a truth. You are promoting dishonesty. You are promoting, to me, corruption. Makes sense? Failure to comply with GDPR. The video recording to which you refer was a public meeting of Anfield Parish Council. No, it wasn't. And as such is not deemed to be personal data. Wrong. Yes, it is. How the meeting came to be called is a matter for the Parish Council. The recording itself is widely available on the internet and social media. Therefore, the emailed link to the meeting forwarded to the monitoring officer in this case is irrelevant. No, it's not. I also note that in paragraph 1.7 of your complaint, you acknowledge that the video recording in question is widely available by virtue of it becoming viral. Yes, we have to do that. This element of your complaint is not upheld. Well, you provided no argument. One, if you're going to, as I have stated, if you're going to video a meeting like that and you're going into people's homes, their places, which is they believe is private, you have got to state that this video is going to be recorded and likely publicly published, because there is personal data on it. What worries me is, it's quite clearly someone's written this letter. The person who's written this letter did not go and speak to their DPO, which means data protection officer. They didn't do it. Because any data protection officer with his or her salt would say, well, hang on a minute, do not put that in a letter. You must not write that in a letter. You cannon fodder. Because that says to me, Cheshire East, again, you haven't a clue what you're talking about. And I can tell you, you saying the emailed link to the meeting forwarded to the monitoring officer in this case is irrelevant. No, it's not irrelevant. He still used a video that he knew was illegal. He was using illegal evidence, and he should have known better. This guy, if this guy is a barrister, he should know the basic rules of evidence. I'm sorry, he should. I've never come across a barrister that does not know the rules of evidence. Do not tell me he does not know the rules of evidence. I know he doesn't know the rules of investigation, and then I will prove yet again. Okay? 1.7, alleged breach of human rights. I would refer to the responses provided above and would reiterate that from the evidence provided, there is no breach of confidentiality or your human rights. What? If you review the Council's records in relation to the complaints of member conduct at Anfield Parish Council, show that in each instance, complaints were dealt with fully in accordance with the Council's adopted procedure. The procedure allows an opportunity at the outset of the subject matter, for a subject member to provide a response to the allegations made against them. The Council's appointed external investigator in this matter has confirmed that numerous attempts were made to engage with yourself and the other subject members. This element of your complaint, therefore, has no foundation, is not upheld. Bullshit. If you do not serve a complaint on someone, you have automatically breached Article 6, Human Rights Act 1998, because that person has a right to a fair trial and a fair trial/fair hearing. Yeah. So you've failed to address that. What you've done is you've ducked. You've ducked out of it. You've wimped away. You've shied away, and you've tried to use spurious, nonsensical comments to defend yourself, to defend your hopeless position. Yeah. In other words, you're hiding behind the face of dishonesty. You're trying to mask the fact you've been dishonest, but you've not done it very well. In fact, you've done it quite pathetically. Also under this heading, there was Article 8, Human Rights. Your investigator can't just contact people out of the blue. You have to do it. You have to provide a notice of investigation, and you did not do it. The monitoring officer did not do it. And as he's the one setting the investigation, it is his direct duty. And he failed. And I will come to that in a later episode, but he failed. So to say that our complaint is not upheld, nonsense. You do not know what you're talking about. All you're doing is a fob off. Whitewash. We also put in our complaint dissolution of Anfield Parish Council. The monitoring officer didn't ask my father and two of the members of the public to help him dissolve Anfield Parish Council. He doesn't need that. That's his duty. That's one of his statutory rights. Has he not got the gumption, the guts, or the temerity to be able to do that himself? I think that's the case. Yeah. And all they write here, in the absence of any evidence to support this allegation, this element of your complaint is not upheld. Absence of evidence. You were given a series of telephone notes that were taken from the telephone calls that your monitoring officer, Mr. David Brown, had with those very people. And you say there was no evidence. You are a liar. You lied. Point 2. Failure to cease and desist from taking action. All they write is, this element of your complaint is not upheld for the reasons set out above. Well, we noted, because there'd been a resignation, bang, that's when it should have stopped. And the discovery of illegality, it should have been stopped. But it wasn't. It was pursued. And now what we got a situation. It was so badly pursued with a path of complete dishonesty, perfidiousness and mendaciousness that 2 people are dead. Bravo, well done. Take a bow. You must feel really proud of yourself. Next one, failure to undertake statutory monitoring officer functions. That this element of your complaint is not upheld for the reasons set out above. Well, no, it's not. You've not answered the question. Any arrangements between Anfield Parish Council and Chalk are a matter for those organisations. There was no arrangements between us and Chalk. So there is no legal obligation for the monitoring officer to consult the people you refer to in the circumstances that there is. We set out a situation where the monitoring officer should have been consulting with people when we highlighted and blew the trumpet on wrongdoing. He has to do it. If he's doing an investigation, he must do it. And he must do it with his investigator. He didn't do it. Instead, he went on. And we get this Mickey Mouse. Failure to make lawful and proportionate decisions. This element of your complaint is not upheld for the reasons set out above. You've not given me any reasons. This is just a wishy-washy load of rubbish. It's absolute rubbish. Stop blowing smoke. When we say failure to take or make lawful and proportionate decisions, we mean on the discovery of unlawful evidence, what do? You investigate how that evidence is not admissible. You stop the proceedings against people. A councillor is resigned. You stop the investigations against him. You stop it dead because he's no case to answer anymore. And as it was, he had no case to answer. Yeah. When you know that a disqualification of a councillor is unlawful, you work with your returning officer and your head of democratic services to get it right. You don't just leave it and drag out time so people can't hit deadlines if they want to take legal action. Yeah. That was the letter we got, and it's absolute baloney. Rubbish. Just blowing smoke. The following day, now bearing in mind I have now had the full report back into the financial matters. I reported this up to Cheshire East and to Audit and Governance. I get a letter from the interim head of legal. I don't think that title should have been used. I think it just should have put village idiot. It would have had much more credence. He writes, I write in relation to your alleged financial irregularities at Anfield Parish Council, which you have raised as part of the current complaints investigations process. No, I haven't. This is completely independent of this. This is nothing to do with the current complaint investigations process. I'd given this to the police. This was a separate investigation. Because under this heading is fraud. You can't give an idiot investigator that, particularly one like the one we had, who hadn't got a clue what you were doing. So that's completely wrong. Given the nature of these allegations, the investigator was compelled to inform Cheshire East Council so that the appropriate action could be taken as necessary. He had no right to get involved. It was not within his remit. From a review of our records, it appears that this is the first occasion that such allegations have been made known to Cheshire East Council. No, it wasn't. They were sent to you. They were sent to you when the report became available the previous autumn. The autumn of 2020. Right? And then you list out just a selection of things You list 5 things. There's more than 5 things, right? And then you write this silly paragraph. Having considered the above matters, we have concluded that Cheshire East Council has no remit to intervene. Pardon? You give Handforth Parish Council the preset, and that it is solely a matter for HBC. What a load of baloney. I can't believe I'm reading this. Look, as soon as you found out the irregularities at Odlum, you couldn't wait to get involved and you got the police in. Oh, but because it's us, you don't want to know. Oh, I get it, yeah. You don't want to know. We're just a poor relations, aren't we? Pathetic Cheshire East. Pathetic. Responsibility goes on. Responsibility for the financial arrangements of the parish council. Concerns over the accuracy, validity, appropriateness of any transactions and the decision-making processes followed should be brought to the attention of the internal or external auditors of the parish council. If you'd read what I'd already given you in the first place, you'd realised that had been done. Then he writes, we understand that Handforth Parish Council is a relevant authority set out in the Local Audit and Accountability Act 2014, and that the Accounts and Audit Regulations 2015 also apply, with the Parish Council meeting the definition of a smaller authority. These pieces of legislation set out the responsibilities of the Parish Council excuse me, in regards to accounting requirements, including the external audit of these accounts, and to undertake in each financial year a review of the effectiveness of the system of internal control and prepare an annual governance statement in accordance with proper practices. Yeah, they've done that, but it's been based on falsities. He finishes off, I trust this clarifies. No, it doesn't. No, it doesn't. It doesn't clarify. It's a load of rubbish. Yeah, it's a load of rubbish. And I had to go back and very strictly and sternly rebuke him on that because it was absolute just hogwash. I could not in any way, shape or form accept that. No. So I actually chose to write back. I actually wrote back, and I wrote back to the chief executive for corporate services, and I said, many thanks for the attached letter, but I have to say, as you probably expect, that I cannot accept its contents at all. I wish to state that having taken legal advice regarding my resignation, that it is entirely valid as the chair of HBC was copied into the email and the attached letter, and this does, in the eyes of the law, constitute service thereof. Yeah. I understand that he has told the clerk and he has told the monitoring officer, but this does not seem to have been conveyed. Therefore, somewhere along the line, there's been a breach of law. My resignation was therefore legally effective from the date of that email. In terms of the notion that Councillor Thompson's disqualification was unlawful is being misconceived, that is entirely incorrect. December 2019 to March 2020 is 4 months and can never be 6. She cannot be taken as missing meetings in April 2020 and May 2020 as there were none, and you cannot be taken to miss a meeting that has not taken place. There has been a grievous miscarriage of justice and misadministration in this sense. I would also respectfully ask if you would be happy to have a complaint supposedly served against you, which never was, and then discover that a determination notice has been issued against you, in which it is incorrectly stated that your response has been considered. Article 6 Human Rights Act 1998 also applies where a local authority seeks to make a decision against you. You must be given a fair opportunity to represent yourself. My legal advice shows that this is the same here. The CEC is seeking to possibly make a decision against me and has failed to afford me that very right. May I ask, did the monitoring officer make an admission to the following facts, which include inter alia? 1. That the original email was sent to my HBC address, which it is known and documented I cannot use. 2. That the claim that the emails were sent to my Yahoo address is provably false, as, after consultation with Yahoo UK, I have discovered from the directory that no such email was ever received or even rejected. And 3. That the law states that all methods of communication must be used in serving documentation. This includes email, facsimile, telephone, post, hand delivery or serve delivery. To just use email is not legally acceptable in terms of service. I had hoped that an acceptable conclusion would have been found, but distressingly this has not manifested itself. I will be making these findings public, as I firmly believe that it is in the public interest to make them so available. In terms of the accusations we made, we never make serious accusations without full evidence. We have that evidence, and we feel that it now needs to see the true light of day. Many thanks for your help, kind regards, and I sign off. Do you know what? I never got a response to that. I thought it was a good email, fairly written, correctly written, positively written. I never got a response. So we get to the middle of April, and we find that Ashley's up to his old tricks. He's being dishonest again. I write to Barry and Bride and I say, dear all, I've had my attention brought to my attention that it appears that Ashley is up to his old tricks again. So a gentleman made a grant application to HPC at the beginning of October last year, that being 2020, and never received a response. I said the application was in relation to purchase of trees for avenues in Merritt Road Park. I said this gentleman believed that the lack of response was due to Ashley being suspended. I said that Ashley wasn't suspended until November. I also said that I did not at any time see the person's email in Ashley's inbox. I have firm grounds to believe, therefore, that Ashley deleted this email and took the decision to refuse to action it. What other conclusion can I come to with the evidence I've got to hand? No email, confusion by the sender, no documentation forwarded to me as Chair of Finance, and Ashley's purge deleted his inbox, and we see it. This application, and I went on, this application has been retabled, but Ashley has said that it can't be actioned because there is a backlog. I said that this was blatantly untrue, as there was no backlog. It seems that Ashley is lying to people to stop grant applications so to ensure that he has more time to carry out the mob's bidding rather than conducting himself in a decent and honest manner. Now, there were several things. I'll finish the email. I finished the email because the last paragraph don't mean it's just a sign off. I actually had a meeting with Brian and several former councillors, and we came to the conclusion that one could have been one of a number of things, or one of several things could have happened. One, he has literally just deleted it, not actioned it, and then he's gone on and he's given this, once upon a time bullshit story to this particular person. Or he is saying to people, forward all that stuff to me. Whilst he was suspended, forward all that stuff to me and I'll hang on to it until I'm back in the office. Knowing full well the mob were going to orchestrate a coup d'etat and pull all the strings to break the law, to commit gross criminal acts, to put him back, and then he would start dealing with it. Or or that they've encouraged people to put grant applications in going to him and through them, not to where they should be going, and they've created a backlog. It's one of those three things, or a mixture of all three. Whatever it is, I don't know. We also decided at this time that it would be beneficial to contact Chorley Parish Council, and we spoke to Chorley Parish Council and provided them with evidence of Ashley's wrongdoing. The chair came back and completely defended him, saying how brilliant he was, da-di-da-di-da. I just despair. How can you, in the face of blatant dishonesty, say, oh no, it's alright, not a problem, I'm not bothered? I don't get it. And on top of that, with him defending Ashley, they redid the website, never just discussed it with anybody, spent money, the 3 babies, and what do we find on the website? There's documents missing. When I say documents, I mean minutes of meetings, full council meetings, planning and environment meetings, finance committee meetings. They're missing. We're getting as far back as 2015, and they're missing. Why? And if you can go on the website now, and if you can find your way around that exclusive website, that menagerie, good one. You get a gold. You might get an Olympic gold medal if you can get to if you can find it. You know, if you can, you will find that there are documents missing. They're not there. The final thing which absolutely finished me off in April was the nonsense over the minutes of the meetings from January 12th and the 18th. I said under no circumstances am I going to apply those, because at this time I still haven't cleared my name from the once upon a time fictitious load of nonsense John Smith had shoved in about me doctoring minutes back from August 27th, 2020. I said there's no way in the world they get them, because they'll change them to suit themselves. It will not be truthful and honest. I said, look, the situation is now, we are now 2 down. We don't have the votes. They will not accept those minutes. So I said, it's better that we keep them and we withhold them. We keep them as our record. Okay? Our undisputed record. I mean, John Smith, he can have his little recording in the Part B meeting, you know, from January the 18th. But the fact is the minutes will mirror that, of course, unless he's doctored it, of course. Anything's possible. You know, I just wouldn't put it beyond anyone. What finished April for us is we sat down with Barry, because, of course, he was dealing with this awful vote of no confidence. And what gets me is this again shows incompetence of Cheshire East. They voted to refer that matter to a committee that didn't exist. They voted to refer the matter vis-a-vis Barry in the vote of no confidence, what was going on here, to the Standards Committee. He didn't have one. They got rid of the Standards Committee back in 2011. And I pointed that out because the thing was, people then were looking for the constitutions for the full council and the committees, and strangely, they'd vanished. They'd gone off the website. That was something else we reported, and you know what? We never got a response. There was councillors I know, Cheshire East councillors I know, brought it up, and they never got a response. There weren't any reasoning. Has it happened? Right. We'll have to look at that. I'll get back to you. We're still waiting. And I tell you what, if you want to get back to Barry now, guys, you're going to have to use a medium. We would like to know why it was at this time suddenly the constitutions of all the committees were taken off the Cheshire East website. We would like to know why it was the full constitution of Cheshire East, which would have shown all the constitutions of the committee, was not published. Why was this done? That was April, folks. Now, I have been asked to do another special on a certain subject, and after much thought, consideration, and consultation with my legal team, I'm going to do that special. So stay posted. Thanks.